With the evolution of time and technology, society has gradually shifted from the original methods of contracting first introduced by earlier civilizations and further refined by the Romans into the law that serves as the basis for our current society, to a contracting system that is more intertwined with the virtual. In Zimbabwe, this is no exception, and the focus of this presentation shall be on examining what role such systems play and how relevant their implementation is. An electronic contract is simply a legally binding agreement settled through the use of digital means. Their traditional counterparts, electronic contracts are a way for businesses or individuals to transact value. The only difference between them and traditional contracts is that there is a technological twist. It is important to note that the electronic contract is the output of a reality increasingly intertwined with the virtual, notably operated by a computer. Robert Mena Pareto. Systems such as the secure contract container, which stores information about accepted liabilities and other details about that, are used to ensure that the electronic contract is settled in a legally viable manner. An example of this are smart technology. Smart technology implements the use of blockchain software. This means that the process of an electronic contract is settled automatically without the need for a third party to intervene. What happens is there is an initial process where the parties that are going to contract meet up together with their legal representatives and decide on terms and conditions that are going to be met. This then moves on to the processing phase, whereby the software engineers and a specialized team are hired to ensure that they develop the software required for the process to go on its own, all until the stage whereby an electronic contract takes place automatically. Other examples of electronic contracts that are especially applying in Zimbabwe are the EcoCash mobile system, where there is an mobile contracts, M contracts, which are determined by a user who requires only a phone to make a contract with another person or another software. In the case of electronic data transfers, when you buy a data bundle, or in the case of electronic transfers of airtime and other such details. Another example are emails. Emails are sent on a regular basis between businesses from countries and within the nation. Email acceptances and offers are done entirely on the line. A popular version of the Click-wrap electronic contract is the Zoom software, which has become popular with the advent of the pandemic, especially in third world countries like Zimbabwe. The Zoom software requires an agreement on the part of the user to click I agree so that they install the software packages that are required to run the software. And several other examples exist of the electronic contracts in use. But what is important to note is that electronic contracts are in use and they are around us in the form of website forms that sell air tickets and in the form of email offers and acceptance.
It is essential that we draw a comparison between the traditional contracts and the e-contracts. The traditional contracts actually are drafted in paper, and so there's paper and ink, and then a physical. So while the traditional contract is drafted on paper, the digital one is done electronically using a digital platform. The parties to a contract in the traditional mode are physically present, but in the electronic contract, there's no need for being physically present. If we were to look at the costs involved, we would note that the traditional contracts have post transactions. compared to the counterpart, where the costs are low. And it is, of course, also time-consuming, while e-contracts are time-saving. We may also want to look at the security of these contracts. When you do a contract using the traditional way, you will notice that it's less secure than the electronic contract, which is quite secure. I could give the example of a WhatsApp platform, where all information is encrypted and for the sender and the receiver. So there is privacy attained there. It is important to appreciate the fact that whether you have entered into a traditional contract or an e-contract, both are binding according to the law. They are legally binding as long as there is a meeting of the minds of the parties to the contract.
Okay, basically, we are continuing with the issue of e-contracts or digital contracts. We're going to look at processes that we actually form contracts. Number one, through the use of emails, where the offerer sends the offer to the offeree, and when the offeree agrees with the terms and conditions, he sends acceptance offer to the offer. We have web contracts, which are formed through the use of web, where one will completely agrees to the terms and conditions when you browse the website. For example, air tickets. One has to buy air tickets in a website. You are supposed to browse. By browsing and buying, automatically you are agreeing to terms and conditions of the buying and selling. We have also what we call online agreements. For example, take a WhatsApp application where you are supposed to click agree so that you agree to the terms and conditions on the usage of the app. We also have agreements. Those agreements contain, for example, trademark policies, copyright policies, limitations to liabilities, and warranties. Then we move on to types of contracts. We have shrink-wrap agreements, whereby the user gets other terms and conditions of using the probably app, for example, a software, which can be an application software. These ones are enforceable only if the terms and conditions don't contradict with the previous terms and conditions that are not inside the shrink-wrap. We also have browse-wrap agreements, where the usage of web automatically binds the one to the terms and conditions of the agreement. We have click or web wrap agreements, where the user automatically use. These are web-based, where it is a software. You have to click agree because the user owns the software. E.g., when you're doing an online shopping, you can click agree so that you are able to purchase anything. Moving on, we have acts that govern the use of e-contracts. For example, Information and Technology Act, which was signed in 2000. This one authorized the use of e-contracts in as much as we can use traditional contracts. We also have e-Sign Act, which was also signed in 2000. This gives legally enforceable signatures is we have e-sign contract, where it is an act of 2000 which gives the e-signatures the law to enforce e-signatures is enforceable in as much as traditional contracts are concerned. We also have Uniform Electronic Transaction Act, which authorized the use of e-signatures and also improve the e-contracts in terms of the issue of commerce. This one only pertains to businesses, governments, and
well, it is paramount to master that an electronic contract is an agreement which is entered between individuals or companies. That agreement is drafted, negotiated, and executed completely online. That agreement must also create a binding mutual obligation which must have legal elements, for example, an offer and an acceptance. It is of paramount to note that different countries have laid debates on when an electronic contract can be executed. For example, it is said that an electronic contract can be executed after noting the different tools, the different communicative tools being used by the contractors on the internet. Also, an electronic contract can be executed after one have mastered the type of a contract being used by the contractors. For example, different laws are being used by different countries. Each country have got its own laws. Us as Zimbabweans, we practice and we have our own laws. Britain have got its own laws. America also have got its own laws. So it is important for one to note what type of a contract has been entered by contractors in order to be able to execute a contract. Also, it is important for one to consider the legislation to be applied. For example, we have different legislations. Different legislations are being used by different countries. So it is of paramount to note which legislation to apply. In addition to that, an electronic contract can also be executed when there is the meeting of the minds between the contractors. Because it is said that when there is the meeting of the minds between the contractors, it means that the contractors have agreed to be bound by the terms of the contract. They have agreed to follow the terms of the contract. Also, for a contract to be executed, one must master whether the contractors have shown the will they must show the will to be bound by by the terms of the contract. After all this discussion, I myself can say that a contract must be executed after one have mastered or implemented that the contractors have seriously agreed on the terms of the contract, or after taking into consideration that all parties have what
reflecting this issue of e-contract, basing with our country, Zimbabwe. Here in Zimbabwe, we also are experiencing some and practicing these e-contracts, but in small commodities or in small. For example, we have what we call e-banking, the transaction we do day in, day out, transferring money. Those are some of the e-contracts, even eco-cash, most famous. But we are limited by certain things or certain resources like internet, Wi-Fi, or even the knowledge that these e-contracts exist. However, we also have to consider and encourage each other, maybe sort of educate the nation of how this e-contract works. Basing that, now we have what we call e-businesses. E-businesses is when we are doing everything online, avoiding face-to-face interaction that may prove to be costly in this time. From what my other colleagues have presented, they have spoken of the advantages and disadvantages of these e-contracts, and we have
did a very good job at directing us throughout the course of this next thing.
And then a physical signature.
Okay.
In terms of the issue of commerce, this one only pertains to businesses, governments, and commerce only.
Seriously agreed on the terms of the contract. After taking into consideration that all parties have what?
practicing these e-contracts, but in small commodities or in small, for example,